Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, I am going to explain a crucial yet often overlooked topic in civil court practice, the difference between exhibits and marks in court documents. This classification plays a vital role in how evidence is accepted and relied upon in trials, especially in civil matters. Whether you are a law student, a junior lawyer, or a litigant involved in a civil case, understanding this distinction is essential. Let's begin by breaking down both terms in simple language. What are exhibits in court proceedings? An exhibit refers to any document, object, photograph, or electronic record that is formally admitted into evidence during the course of a trial. Once a document is admitted by the court after following due procedure, it is assigned an exhibit number or code, such as Exhibit P1 for plaintiff side evidence or Exhibit D1 for defendant side evidence. Admission of a document as an exhibit means that the court recognizes it as valid evidence, and it can now be used and relied upon during cross-examination, arguments, and while writing the final judgment. Some common examples of exhibits include sale deeds, agreements, medical records, photographs, check return memos, electronic records like emails and WhatsApp chats, or CCTV footage accompanied by the necessary certification. Legally, this process is now governed by the provisions of the Bharatiya Sakshya Adhiniyam, 2023, which has replaced the Indian Evidence Act, 1872. Under this new law, Sections 57 to 63 lay down the principles for proving documentary, digital, and electronic evidence in Indian courts. These provisions simplify the process of proving documents and recognize electronic records as primary evidence when their authenticity is established. What are marks on court documents? On the other hand, a marked document is any document that has been produced before the court and has been identified and labeled for reference, but has not yet been admitted into evidence. Such documents are marked for identification only and are usually labeled as Mark A, Mark B, Mark X, Mark Y, etc. Marking simply acknowledges that the document exists in the court record, but it carries no evidentiary value unless it is later proved and formally admitted as an exhibit. These documents may remain as references unless the court admits them into evidence after fulfilling all legal requirements, such as proving authorship, authenticity, proper stamping, registration, or certification. Typical examples of marked documents include photocopies without the original, unregistered agreements, or documents whose authenticity is challenged by the opposing party. Key differences between exhibits and marks. Now that we've understood the basic definitions, let's understand their key differences in legal impact. The first major difference is admissibility. Exhibits are documents that the court has admitted as evidence, whereas marked documents are only identified but not yet admitted. Therefore, while an exhibit has legal and evidentiary value, a marked document does not carry any evidentiary weight on its own. Secondly, only exhibits can be cited and relied upon during final arguments and in the judgment. Marked documents cannot be relied upon unless they are converted into exhibits. Thirdly, the labeling system differs. Exhibits are numbered or lettered systematically, like Exhibit P1, P2 for plaintiff or D1, D2 for defendant. Marked documents are usually labeled alphabetically or generically, like Mark A, B or Mark X, Y. And lastly, while a marked document may seem significant on the surface, unless it satisfies the rules of evidence and is admitted, it will not support your case legally. This is a critical point. Just because a document is in the court file does not mean it is part of the evidence. What the courts have said, case laws. To reinforce this distinction, let's look at some important judicial pronouncements. 1. In the case of Kalia v. State of Madhya Pradesh, 2013, 10 SCC 758, the Supreme Court observed that the mere marking of a document does not mean it has been admitted into evidence. Marking is an administrative act, whereas admission is a judicial act. 2. In Saith Taraji Khimchand v. Yelamarti Satyam, 1971, 1 SCC 562, the court clearly held that production and marking of a document is not enough, it must be proved and admitted as evidence to be relied upon. 3. In a recent Delhi High Court matter, 2022, it was clarified that documents merely marked cannot be relied upon by the court while delivering the final judgment unless they are admitted after legal proof. These rulings make it clear that courts distinguish sharply between marked documents and exhibits. Practical tips for litigants and junior lawyers. Let me now share a few practical tips from my own experience in court. Raise timely objections if the other party is trying to introduce a document without following proper legal procedure. Object at the time of marking. If you remain silent, the court may consider the document admitted without challenge. Use evidence affidavits in civil cases. Evidence is often submitted through affidavits under Order 18 Rule 4 of the CPC. Attach all relevant documents and explain in the affidavit how each is genuine and relevant. This helps in smoother admission. Be careful with electronic records. Under the Bharatiya Sakshya Adhiniyam, 2023, electronic or digital records are governed by sections 61 to 63, which treat them as primary evidence if their authenticity is properly established. Although the old Section 65B certificate is no longer required, the party producing such evidence must still prove its integrity and genuineness through technical means such as metadata, hash values, server logs, or digital signatures. Without such proof, even WhatsApp chats, CCTV footage, or emails may be only marked for identification but not admitted as evidence. Original versus certified copies. Always try to submit original documents. In some cases, certified copies can be accepted, like registered sale deeds, but you must still prove their relevance and authenticity. Why this matters in your case? You might spend months collecting documents, but unless you know how to get them admitted as exhibits, they will not help you. A strong document is legally useless if it is only marked and never admitted into evidence. Understanding this difference ensures you present your case more effectively and respond smartly to objections from the opposite party. Key takeaways. Let's recap the key points. Exhibits are documents that have been admitted into evidence and can be relied upon in court. Marked documents are only identified for reference but do not hold legal value unless admitted. Just submitting a document is not enough, it must be proved and admitted. Raise timely objections and follow all procedures for proving documents. This understanding can make or break your case. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind!